Hey out there, legal warriors. This is a very important video. It's about how bail bonds work in Washington State. Even if you're not charged with a crime, you may know somebody who gets charged with a crime one day, and what we want to do is get somebody out of jail if they're there. So how does that work? If you're interested in this area of the law, stay tuned because this is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm's been defending people charged with crimes for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like, please subscribe. More people will get the help they need, and that's really what we're trying to accomplish here. So I'm just going to jump right into it. Bail bonds. How do they work? I mean, even if you've been involved in the system, you may not understand it. And it took me quite a number of years to learn the ins and outs. And I've got a lot of made a lot of friends in the industry who sort of give me some tips over the years. So I'm going to cover the basics of how bail bonds work. You know, when does bail get set, and what do you do if bail gets set? What are the risks if you post bail? What are the risks to the person who gets bailed out? What rights do they give up? And things to consider if somebody has been arrested and you're trying to figure out how to get them out of jail. So let's just start from the beginning. How does a bail bond work? Well, in the very most basic way to think about it is a bail bond is the court has ordered a defendant to be in jail and post some security to get out of jail to obey by the court's conditions going forward in the case. And the most common condition we think about is to make sure they come back to court, right? So they're afraid that, hey, if someone's charged with a crime and if they don't post any money that we hang on to until the case is over, then they won't come back to court. The court can also post a bail bond, or not post a bond, but set a bail amount that has to be posted with certain other conditions like, hey, wear a GPS monitor, or don't drink, don't commit any crimes, things like that. And if somebody violates those conditions, their bail can get revoked, and then they can lose that collateral that they posted. And so let's just take an example case. The most common case you might see would be like a DUI charge. Someone gets arrested for DUI, that happens all the time, and they get taken to jail. And then in a DUI case, the laws in Washington State says there's not a default bail that's typically set. In a DUI case, the judicial officer has to set a bond, either release someone with conditions or set a bail amount. And let's say the next morning, the judicial officer, a judge of some sort, sets a bail of $5,000. Now what? You're looking on the jail register, look on the jail register online, Snohomish County Jail Register, King County Jail Register. They'll see a number there. It may say $5,000. Well, that means to get the person out, somebody can either pay $5,000 to the jail, which you may not have sitting around, that you're going to get back at the end of the case, or most of it back. Sometimes there's some fees if the defendant obeys. Or you can go to a bonding company and pay them a fee for them to take the risk themselves and post a bond, a promise to pay the court $5,000 if the defendant disobeys the conditions, doesn't show up for court, violates other conditions. And the fee that you pay the bonding company is typically 10% of the bail amount. Okay, so in a $5,000 case, you're going to pay $500 that you'll never get back, plus some miscellaneous stuff sometimes. If you have a private attorney, the way I think about it is the surety, the person that insures the bonding company's risk, allows them to only charge an 8% fee. If there's a private attorney involved, so that'd be $400, because those private attorneys are going to probably make sure that our client shows up a little better than someone who's not represented, right? Or someone with a public defender. So on a $50,000 bond, a bail amount, it'll cost you $5,000 to get someone out. On $500,000, $50,000. And as the bonding company's risk goes up with the bigger numbers, they may ask for collateral, right? There's different amounts for different bonding companies, but the collateral might be a credit card swipe for the whole $5,000 if they think that this person is a bad risk, and we're going to refund all but $500 once they do everything they're supposed to do, because that might be your only choice, right? What if you're in Texas? You're not going to drive up to the jail in Washington and with $5,000 cash, are you? A lot simpler to call a bonding company. Let's say it's a $100,000 bail. Well, maybe they want to take a lien on your home in case the defendant runs off to another country, right? and never comes back. So so how it works in general is you pay a percentage to the bonding company for them to take the risk and post a bond, or you pay all the money yourself to the jail or the court, depending on the situation. And then once that gets processed, the suspect is now out of the jail. Okay? So what are some other things that need to be considered? What rights does the person who is the subject of the bail or bond give up? Well, in a bond case, the bonding company will make them sign a contract typically that says, basically, I give up a lot of my civil rights as the person bonded out to a company to give the company the ability to go find that person if they run. Right? You ever see Dog the Bounty Hunter? We see him going into people's homes. Well, it's because that would be illegal normally, but in most bonding contracts, there's going to be a provision that says, hey, we're allowed to go into your home. We're allowed to do all these things to try to find you if you run. And also, if you're the person who signed on the bonding contract, who paid the money to get the person out, you're going to be liable, typically in the contracts, to the bonding company for the amount of money that's on the bond, and even more to try to catch the person. So read what it says. It doesn't happen in real life, but you take a risk if you're signing, and the person who's getting out on a bond usually signs away some of their rights. Now, 99 times out of 100, I hope, at least in my clients, no problems, right? But realize those are some of the extra, gotchas in the situation that you have to at least think about and worry about when you're trying to get someone out of jail, right? And what rights you give up. I think another thing that we have to realize in the bonding situation, if you've taken a big risk as the person posting the bond, you can ask to have that bond revoked. Let's say you've got your house up on the line and you don't like how little Billy Bob's acting, he's using drugs again, and you don't think he's going to show up for court, he's going to commit a crime. Well, you can tell, Billy Bob in this example, that, hey, if you don't straighten up, I'm going to have the bonding company revoke your bail and put you in the jail. And once you could say, I don't want the risk anymore, so okay, we won't take the risk. They'll pick him up, they'll put him back in the jail, they get their bond back, you're no longer on the hook, but Billy Bob's back in jail. Okay, so those things can happen also. But let's take it a step back. Let's go back to the practical situation. The common case, what a court considers and whether or not they're setting bail, is supposed to consider a couple different things. They're supposed to consider the past history of a defendant failing to appear. They're supposed to consider the likelihood of a person reappearing, like if they have a serious charge and they're from another country, they might make them turn in their passport or something so they can't flee the country. And they're also to consider the danger to the community, whether or not it's a violent offense or not. And a violent offense is a term of art. It's a legal term. Even a DUI is labeled as a violent offense, even though there's no violence happening probably, right? So they take a look at those things, and when a bail is set, for the more times than not, there's a hearing where the prosecutor asks for a certain amount of bail and the defense asks to have a lesser amount or to have someone released without bail, and that's called personal recognizance. If you're watching this and you had a loved one in jail, what you want to do is you want to talk to a defense attorney, right, to see what they know about when a hearing might be set, because when someone's in jail, there's no one to get a hold of. It's very hard, if not impossible, to call the jail, and oftentimes it happens late at night or on the weekend. You can't call the court. But if you call an experienced defense attorney, they will have a good idea, hopefully, if they're experienced in that court, about what they think is likely to happen. Don't ever hold the poor attorney to it, because things change all the time. But usually, if we've done this for a while, we're more often right than not. And then if you can't get a hold of an attorney, keep refreshing the website that shows if there's a bail or not. If you see something that says, assault to INV, that means INV means investigation, and there won't be typically a bail yet, because let's say if it's a domestic violence case like a DUI, the court is required to review some stuff to protect the victim and the public before they either set a bail or release somebody. If you see a number on there, it says 7,500 or 10,000, well, that's likely the only bail that's set. As long as you don't see any that are blank, you'll see all the charges, they all have a number. Then there's probably a default bail that's set by court order upon arrest for other types of cases like a theft or something like that. Or there's already been a hearing that you didn't know about where they set the bail. Now, once you see that number, then you're able to get a hold of the bonding company and get them to do what they do to get your loved one or the person that you care about out of jail. So that's how a bond works. It's a pretty clunky system. It's been changed in California. In Washington, it may get changed also. So basically, it's an amount of money you pay to get someone out, or that a bonding company posts a promise to pay to get someone out and charges you a fee that you never get back. So if you post the money yourself, you'll get most of the money back if the person obeys. If you pay a bonding company, you'll only get your collateral back. You won't get the fee back if the person obeys. So I hope you found that useful. I got into the weeds there a little bit, but for the most part, I think I've covered what you need to know. And if you find this useful, please like and please subscribe. And more importantly, if you know someone who's charged with a crime, if you're trying to figure out what to do, if you need some legal help in a criminal matter, feel free to give my office a call. We'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.